everyone, this is Ishita, the legal intern at LEXIS and Company. Today I'm gonna brief you out about the plea to decriminalize begging. The Supreme Court has asked the centre and four states to respond to a plea to decriminalize begging. These states include Maharashtra, Gujarat, Punjab, and Haryana. Background: the court in February 2021 sought a response from the centre and five states on the plea, which claimed that the sections of the statute criminalizing begging were violative of constitutional rights. What's the case? The plea has referred to August 2018 verdict of Delhi High Court, which had criminalized begging in the national capital and said provisions of Bombay Prevention of Begging Act 1959, which treats begging as an offence, cannot sustain constitutional scrutiny. It argues that the provision of statutes criminalizing the act of begging but put people in a situation to make an unreasonable choice between committing a crime or not committing one and starving, which goes against the very spirit of the Constitution and violates Article 21, that is, the right to life. Other issues were involved. As per the census 2011, the total number of beggars in India were 4,13,670, and the number has increased from the last census. The government has mandated to provide special security to everyone and ensure that all had basic facilities as embedded in the DPSP's directive principles of state policies in the Constitution. However, the presence of beggars is evidence that the state has failed to provide these basic facilities to all its citizens. Therefore, instead of working on its failure and examining that what people made beggar criminalize the act of beggary is irrational and against the approach of a socialist nation as embedded in the preamble of our constitution. Begging is also a peaceful method by which a person sought to communicate their situation to another and solicit their assistance. Thus, criminalizing begging is a violative of Article 19(1)(a), freedom of speech guarantee. Beggary laws in India. As such, there is no central act on beggary. However, many states and union territories have used certain sections of the Bombay Prevention of Beggary Act 1959 as the basis for their own laws. The Act 1959 criminalizes begging. Though these legislations, the governments try to maintain public order, addresses forced begging or begging rackets, prevent annoyance to the tourist. Now, the way forward, the centre made an attempt at repealing the act through the Person in Destitution, Protection, Care and Rehabilitation Model Bill 2016, with the provisions including doing away with the Beggary Act and proposing rehabilitation centres for the destitute in each district. Persons in Destitution Bill 2016 need to see the light of the day. Bihar's government's Mukhyamantri Nirvana Yojana is a scheme worth emulation. The scheme, instead of detaining persons under the Act, provides for open homes and community outreach for destitute persons. Now, rehabilitation centers have been set up with the facilities for treatment, family and reinstitution and vocational training. The very real problem of organized begging rackets will have to be addressed by other means, perhaps based on the law of trafficking. Bombay Prevention of Begging Act 1959. The Act defines beggar as anyone having no visible means of subsistence and wandering about or remaining in any public place in such condition or manner as makes it likely that the person doing so exists by soliciting or receiving alms. Begging under the Act includes soliciting or receiving alms in a public place, whether or not under any persistence of singing, dancing, phone, telling, performing, or offering any article for sale. The Act also authorizes detention of the family of the beggar. sanctified institution or detention centers have absolute power over detainees. So guys, that was all with the today's news. I hope you liked the video. Please do like, share, comment and subscribe the channel for further updates. Thank you.